Hello, Trevor Prentice here from the IP Link at theiplink.com. Have you ever wondered what criteria your product needs to meet in order for it to be accepted by the Patent Office? Well, don't miss this video to learn all about it. Comment below or get in touch if you have any questions. So you may have heard about the patentability criteria, or how difficult it can be to get a patent. And the reason that this is the case in some situations is that after you've filed your patent, the Patent Office in each country will eventually take a look at your application and go through to determine if it meets their criteria. And if it meets these criteria, then they'll accept your patent application and it will become an official issued or accepted patent. If it doesn't meet these criteria, then your patent will get rejected. Now, it isn't always one or the other. Sometimes there's a little bit of room in between where some part of your patent gets accepted and some part gets rejected. But I won't talk too much about that in this video because I want to hit on exactly what are these criteria and why is it so important to know about them prior to jumping in with a lawyer or going to get your patent application filed. So the first patentability criteria is called usefulness. And this one's not too tricky to meet. I mean, most of the companies and entrepreneurs that I talk to have a product that does serve some use in the market. The primary reason that this criteria exists is because in some cases, maybe you've got a new design for a product that already exists. So you're not really developing something that's a new use. It's just a new design for an existing use. In that case, then patents don't really make as much sense for your product. You might want to consider something like an industrial design application, which is called a design patent in the United States. So the Patent Office has this criteria usefulness partially so that they can sort of divvy up, all right, these should be patents and these should be industrial designs. So if you do have a unique design for your product, but it doesn't really serve any particular use or benefit to the customer, then you might consider an industrial design instead. The second criteria that I'll talk about is called novelty. And basically what this means is just that your product has to be completely new. Now, as you might imagine, it's pretty tricky to determine whether or not your product is completely new, something that's never been done before in the history of humanity. That's a bit of an exaggeration because, of course, if someone created your product, let's say years ago, and they never told anyone about it, they never published it, they never filed a patent on it, then really there's no way that you could know that they did that. So really what we're talking about here is determining whether or not your product is new above and beyond everything that's been published or patented before. Now, all patents published, so those also count as publications. So if there's someone out there who's done something similar to you, they have a similar product and it's known to the public, so either they're selling it or they filed a patent on it and that patent has published, then that means you likely can't get a patent on whatever it is that's already been done before. One subtlety with novelty, or whether or not your product is new, is that even if you yourself publish or publicly release your product, then you can no longer get a patent on that anymore either. And so this means it's very important that you sort through exactly when you want to release your product as compared to when you try to file your initial patent application. And ideally, that patent application would get filed before you publicly release your product. Now, there are some grace periods. So US and Canada, for example, have a grace period for 1 year within which you can still file your initial patent application, even if you've already published within a year. But most other countries don't have that. So once you publicly release, you actually lose the ability to file a patent in those countries. Now, I'll talk a little bit about how you determine whether or not you meet these criteria in a second, but let's just touch on that third criteria first, which is obviousness. Now, obviousness is a legal term that the Patent Office likes to use, but really what they're talking about here is that you have to have something innovative. So this is a bit of a subtlety, and it can be a tricky criteria to determine whether or not you actually meet it. But let's say that you are able to determine, or at least you're able to gain some confidence on the fact that your product is new. So there's nothing else exactly like it that you can find, especially after doing an in-depth search. But you haven't really had to innovate a lot above the closest similar product to yours. So maybe all you're doing is tweaking one component, and anyone could have thought about tweaking that thing, and obviously that would result in the result that your product gives or the benefit your product gives. Another example is maybe you're combining two known products, and if someone, let's say, who's in your industry and they understand a lot of the different products that exist in your industry, if they were to be faced with your same problem or the same problem that your customers face, would they immediately think, okay, well, I could just combine these two things and that solves the problem? It's relatively obvious. If you were to put these two things together, it would solve that problem. Here's a really simple example. I mean, imagine if you had a pencil back in the day, let's say, one of the first pencils to be invented, and people kept writing, and then they'd make mistakes, so they'd have to erase what they've written. You would always have to go then find your eraser, go grab it. So if you were to develop something like putting an eraser on the end of a pencil, the patent office might think that change or improvement on the product could be considered obvious, because all you're doing is combining a pencil and an eraser, sticking them together. And the eraser still does what it normally does, it erases. The pencil still does what it normally does, it writes. You might be able to overcome an objection like that if you talk about the specific shape and size of the eraser. So this is sort of a much smaller eraser shaped in a cylindrical shape, just like the pencil is. You might be able to try and overcome those objections, but hopefully that type of situation gives you an idea as to what this innovative criteria or the obviousness criteria really means. So if you meet all three of these criteria, then your product is likely to be patentable, and hopefully it will be accepted by the patent office down the line. Now, unfortunately, you won't be able to find out officially from the patent office until 3 or 4 years into the process, depending on how you approach the process. So it's very important up front to determine whether or not you meet these criteria, or at least to give yourself as much confidence as you can before spending a lot of money on filing your patent and then, maintaining it and filing in additional countries. Before spending all that money, you really want to gain some confidence that you meet these criteria. So one of the best ways to do this is to do a really in-depth and thorough patent search. Searching existing patents and even prior art outside of patents, so other types of publications, will start to give you a better sense of whether or not your product is new, especially, and you'll also start to get an idea as to whether or not it might be considered obvious. Now, this isn't a simple or easy thing to do. It can take some time, and this is one of the things that the IP Link really helps our clients with to a great degree. So if there's something you think you need help with or something you're starting to get into, then please get in touch and let me know if that's something you might need help with. And again, it is something really important to think about if you're getting into the patent world, if you're considering filing a patent, because if you don't figure this out or get some confidence up front, then you start to spend a lot of money, and that money kind of builds and piles, and eventually you get to the point where the patent office is reviewing your patent. You might be $50,000 to $100,000, maybe even more, into this whole process, depending on how many countries you file in. And you really don't want to get a rejection notice at that point, because then it's sort of like all that money you've spent has been wasted to some degree. Now, like I said, it's usually not an outright rejection of your entire patent. It could be part of your patent, but still, it's not a great thing to hear. So, it makes a lot of sense to review the patentability criteria in great detail before spending that initial 10 grand to get that initial patent drafted, or whatever it ends up costing. So hopefully this video has been useful to you. Thank you very much for watching. If you found this helpful and want to make the most out of your investment into patent protection, then join our newsletter and gain access to our free patent training webinar at theIPlink.com/patent. In addition to joining our newsletter, make sure to subscribe on YouTube and join our brand new Patent Mastermind community. The links are in the description below. Thanks for watching.